Good afternoon, everyone. Thanks for joining us today to discuss navigating the regulatory landscape for Ontario's second round cannabis lottery. This is Jeremy Burke speaking, and I'm here with Karen Fung from EY. Karen is a vice president in the Transaction Advisory Services Group at EY. She's got 15 years of experience advising both the private and public sector. Karen's advised all three levels of government in a diverse capacity. In the private sector, Karen specializes in assisting companies with crisis management, resilience planning, and working through financial difficulties. Thanks for joining us today, Karen.
Thank you, Jeremy.
I am a partner in Airden Burles's corporate commercial group. I'm a partner in the Cannabis group. My cannabis practice has sort of taken over the rest of my corporate commercial practice over the past couple of years. I do regular work in cannabis regulatory and corporate and commercial matters for clients in sort of all aspects of the industry: federal licensed producers, provincial retailers, licensed producer and retailer applicants, and then ancillary businesses in the cannabis industry, of which there are many: packaging suppliers, cannabis accessory manufacturers, not-for-profits. We also work with First Nations and foreign cannabis companies, amongst others. So we're going to get started. We have about 50 minutes to chat with you, and I'm told that you can ask questions as we go. There's a question panel, I think, on the left-hand side of your screen, so feel free to submit questions. We'll answer what we can at the end of the presentation. We already have 15 or 20, it looks like, so we'll cover some of those during our discussion and answer what we can at the end. So this is the table of contents is in front of you now. And we're going to start just with a quick background on the regulatory landscape, just so we can sort of paint the picture. I'm going to try to move through this pretty rapidly because I think most of the listeners today are interested in the lottery itself, and I really just wanted to provide a basic framework for cannabis legislation because it's relevant to understanding what you would need to do as an Ontario cannabis retailer. So all three levels of government participate to one degree or another in the regulatory framework for cannabis production and cannabis retail. The federal government's jurisdiction is primarily focused on establishing, creating a regime that will supplant the illegal cannabis market eventually, and limit the exposure of young persons to the drug. The Federal Cannabis Act does that in part by designating certain activities as criminal offenses, which are subject to fines or imprisonment. These are things like possession of cannabis other than as authorized by the statute, unauthorized distribution, etc. The Federal Act also establishes the licensing regime for the cultivation and processing of cannabis. It establishes the permitted forms of cannabis, currently plants, seeds, oil, and flower, soon to add edibles, extracts, and topicals. And it defines what components of the cannabis plant constitute regulated cannabis, which is currently all components, essentially, other than non-viable seeds, bare stalks, or roots. And the Federal Act establishes highly restrictive promotion and advertising rules, packaging and labeling requirements, and a host of other rules aimed at regulating the legal cannabis industry. A lot of those rules apply to cannabis retailers, not just cannabis producers that are federally licensed. The Federal Act delegates authority to the provinces to regulate the distribution of recreational cannabis within the province. And all of the provinces have taken up that jurisdiction, provided that the provincial legislation has to uphold the policy goals, essentially, of the federal legislation, which are prohibiting sales to young persons, requiring that the only source of recreational cannabis be from federally licensed producers, and requiring provincial retailers to take measures to reduce the risk of diversion of recreational cannabis to the illicit market. Provincial legislation also regulates matters ancillary to sale and distribution of recreational cannabis, including transportation of cannabis, permitted places of consumption, and a few others. Some provinces have, in fact, raised the minimum age for consumption of cannabis. or reduce the home grow and possession limits that are set out in the federal legislation. And we'll talk about the Ontario legislation in a little bit more detail momentarily. Municipalities also play a limited role, more connected probably to federal facility licensing than retail. But unlike the federal and provincial governments, whose powers originate from our Constitution, municipal governments only have powers to the extent they're delegated by the province. Generally, those powers include the ability to regulate both businesses and land use under, in Ontario, the Municipal Act 2001 or the City of Toronto Act and the Planning Act. But with respect to cannabis in particular, Ontario municipalities have had their usual powers truncated. In particular, the Cannabis License Act provides that municipalities do not have the authority to create a separate licensing regime with respect to the sale of recreational cannabis, or to pass bylaws, in other words, zoning bylaws, regulating the location of a cannabis retail store. A cannabis retail store can be located anywhere that is zoned for retail, essentially, in the applicable municipality. So the licensing system for the regulation of businesses that sell cannabis falls entirely within provincial jurisdiction. For recreational cannabis and for the sale of medicinal cannabis, it's entirely within federal jurisdiction. The provincial cannabis statutes, with one exception, don't apply to not just to the sale, but to anything to do with medicinal cannabis. The only provincial rules that apply to medicinal cannabis are the rules, or the primary rules anyway, that apply to medicinal cannabis are the rules restricting how you can transport medicinal cannabis in the province. The other important thing to note about municipal powers are that municipalities had a right to opt out of accepting cannabis retail stores within their boundaries prior to January 22nd, 2019. 77 municipalities of just over 400 in Ontario opted out. So for anybody who's securing retail space, I'm sure you all will have already, but that should be the first thing you check, is that your municipality hasn't opted out. That list is available on the AGCO's website. Okay, so the specific regulatory landscape for licensing in Ontario, just very quickly, the model in Ontario, as I'm sure most of you know, is that physical stores are the physical sale of cannabis. Sale at physical stores is done by private licensed retailers. Online sales are done only by the Ontario Cannabis Store. The Ontario Cannabis Store is also the sole point of wholesale distribution of cannabis to physical stores. The applicable legislation in Ontario is the Cannabis Control Act, the Cannabis License Act, and the Smoke-Free Ontario Act are the key statutes. I'm not going to go into great detail on those. We'll talk about, just very quickly, the Cannabis Control Act regulates the possession, distribution, sale, purchase, and transportation of cannabis and consumption by minors. The Cannabis License Act, of course, regulates the licensing of authorized retailers of recreational cannabis. And the Smoke-Free Ontario Act specifies permitted places of smoking and vaping. I guess the one point I'd mention there is that municipalities have the ability to, if they intend to be more restrictive than the Smoke-Free Ontario Act, they can also pass bylaws that further restrict permitted places of smoking or vaping. The regulator for cannabis is the AGCO, which makes perfect sense. It was already regulating alcohol, gaming, and horse racing to a certain extent. So it had all the necessary infrastructure, or much of it, to take on the regulation of cannabis retail. The AGCO, in addition to the statutes I just mentioned, the AGCO has issued their registrar standards for cannabis retail stores. These standards, the standards reiterate and summarize certain federal and provincial statutory requirements, but they also add additional rules at a more nitty-gritty level relating to store premises and operational requirements, equipment, security, preventing unlawful activities, employee training, inventory security. It's really important that retailers become intimately familiar with the AGCO's registrar standards. The standards are principles-based, which is good, rather than prescriptive. So In some provinces, the regulator has set out in painful detail, what the security requirements have to be, the size, the thickness of hinges, and the like. Whereas the AGCO has set out principles on which, there has to be reasonable security, and they make sure that those standards are satisfied essentially by inspection and understanding what's actually been done on the ground. So the three licenses that are required are a retail operator license, the ROL, a retail store authorization, and that's one retail store authorization for each location, and a cannabis retail manager license for anyone who's performing certain management functions. Very quickly, I don't want to spend too much time on operator eligibility, the basic rules, because we're going to talk about the lottery rules as well, which sort of sit on top of the statutory rules. But operators have to be at least the age of majority. They have to prove, or at least not disprove, that they're financially responsible. The AGCO has to be satisfied that they'll be conducting the operations in compliance with law, with honesty, integrity, and in the public interest. The AGCO will refuse an application if the applicant's been convicted of certain offenses under the new federal or provincial cannabis legislation or the Controlled Drugs and Substances Act, or if they believe that the applicant may still be participating in the illicit cannabis industry. But by itself, involvement in the illicit cannabis market prior to legalization is not a bar to participating in the legal retail industry. The AGCO's eligibility analysis includes consideration not just of the applicant, but of persons interested in the applicant. These are, for example, directors, officers, shareholders, and also third parties, landlords, lenders, brand licensors, service providers. And that evaluation, I think there's sort of three main goals of those investigations of both the operator, the applicant, and persons interested. The main one is the primary legislative goal, which is to give the AGCO the ability to ensure that the license holder itself is a responsible actor and mitigate the risk that organized crime or other unlawful actors are going to have an opportunity to pull strings in the lawful cannabis retail market. A second goal is to ensure compliance with what I think of as public policy legislative goals, such as the Ford government's desire to exclude federal licensed producers from direct participation in the retail cannabis market in Ontario. And the third goal is to allow the AGCO to ensure compliance with the lottery rules themselves, which we'll discuss shortly. Moving on to store requirements, there's quite a number here. I'll go through them quickly because some of them may be news to some of you, and you may want to ask questions about those. But as I mentioned, the store has to be in a zone, a retail zone, a commercial or retail zone. There has to be at least 150 meters between the store and any private or public school. The premises have to be separated from any other commercial activity, although there is the possibility of locating a cannabis retail store inside an enclosed mall if certain conditions are met. Stores can only stay open until 11 p.m. Only in-person sales are permitted. No delivery, no online sales, no telephone sales. All store employees have to undergo mandatory training. Nothing can be visible, essentially, or cannabis accessories cannot be visible from the outside. There are security requirements. Obviously, minors, minors aren't permitted into stores at all, which is a little bit different from the alcohol licensing regime. And operators are also required to take reasonable measures to ensure that patrons aren't purchasing cannabis for minors. We're not sure exactly what reasonable measures entails, but that's the language used. And also signage has to comply, and any in-store marketing as well, with Federal Cannabis Act promotion requirements. The other important thing to mention about store requirements are that for each retail store authorization before it's issued, in addition to inspections, the store has to pass a public input stage which gives the applicable municipality and residents of that municipality a 15-day period to make written submissions to the AGCO about whether issuance of the retail store authorization for that location is in the public interest or not. Public interest is a defined term in the statute. It has to relate specifically to protecting public health and safety, protecting youth, and preventing illicit activities. So, complaints about traffic or things like that are not going to be effective. And the last piece about stores are that, as I mentioned, federal licensed producers are the only permitted source of supply through the Ontario Cannabis Store as the wholesale distributor. And the only things that you can sell in a store at this point are cannabis, which is as it's defined in the federal statute. So currently, just the current permitted forms: plant seeds, oils, and flour, and soon to be edibles, extracts, and topicals as well. So cannabis, accessories, and shopping bags are the only three things you can sell in an Ontario Cannabis Store. So on to the lottery rules. Very quickly, how did we get here? And that was actually one of the questions we got initially was, what is the Ontario government thinking? So I can't report on what the Ontario government's thinking, or at least I wouldn't in front of 300 people. But the original plan under the Ford government was to allow any licensed retail operator to operate up to 75 retail stores, with each store requiring its own authorization. There was to be no cap on the number of storefronts permitted in a particular municipality. So that was the base. From the outset, federal licensed producers, together with their affiliates, were only to be permitted a single store authorization, and that store was going to have to be connected to their federally licensed production facility, physically connected. Those remain the underlying legislative rules. And unless the Ontario government commences a third phase-in allocation at some point, then those underlying rules will become law again on July 3rd, 2020, so a year from when the most recent regulatory amendment was made. So that's how we got to the first lottery. And the first lottery, it was announced in December 2018. The regulation under the Cannabis License Act was amended to permit 25 store licenses, and the license applicants were to be selected by a lottery, which we all know about. The regulation was amended to prohibit licensed producers from receiving any of the first 25 licenses. And then the AGCO developed the lottery rules to govern how the lottery itself was going to be conducted. The goals of the rules were to promote the opening of stores by April 1st, 2019. That was I'll call it the political mandate, because that was the date announced by the government when it first talked about opening private licensed cannabis stores. And the rules were also intended to disincent monetization of licenses by lottery winners. Those goals were affected by requiring that anyone who won the lottery submit a $50,000 letter of credit that would be drawn on if stores weren't open by April 1st. And winners were required to submit their retail operator license application within 5 business days after the lottery win. The other rule, the rule sort of aimed at disincenting monetization or people, not serious retail operators entering the lottery. There was a rule established that applicants couldn't undergo a change of control for at least a year after the lottery, until the lottery period was ended. That lottery period was initially December 2019, ending December 2019, but it's now not ending till July 2020. So there's an effect there for the first 25 lottery winners. In any event, given the perceived value of a retail license, the disincentives didn't really do the trick, and there were about 17,300 lottery participants in the first go-round. And of course, the unsurprising result was that the 25 winners were, mostly unprepared individuals, unprepared to enter the cannabis retail market, which sort of, self-sabotaged the goal of opening by April 1st and also avoiding the monetization of licenses. And it makes sense, right? The lottery winners were under extreme pressure to move fast, and they were required to comply with a very complex regulatory regime. So it was natural that they'd be open to considering the support of sophisticated retail operators, who in turn were, of course, eager to offer their support, and often on generous terms, in order to earn a foothold and a first mover advantage in Ontario, Canada's largest recreational retail cannabis market. So the outcome was that only a couple of the 25 stores actually opened on April 1st, and some of the lottery winners really did win the lottery. As of today, there are 23 of 25 stores open, I believe, and I understand that one of the remaining 2 will be open very shortly. So that brings us to today, the current allocation, or July 3rd, when the current allocation was announced. Again, it was announced it was going to be conducted by lottery. Licensed producers, federal licensed producers, are again prohibited from receiving any of the 50 allocation, as are any current retail license holders. So anyone who already holds a license is just automatically not qualified to receive another one. 42 of the 50 allocated stores have been allocated to specific municipalities or regions, 6 in the GTA, excluding Toronto, 13 in Toronto, 7 in the East region, 11 in the West region, and 5 in certain northern region cities. The remaining 8 of the 50 are allocated for to go on First Nation lands. Those 8 are not part of the lottery, but are supposed to be issued on a first-come, first-served basis, with the application period opening on July 31. Applicants for those 8 have to have a band council resolution in hand when they submit their intent to apply, approving a cannabis retail store on the proposed site. So that's the allocation. The basic lottery eligibility rules and avoiding disqualification, which I think is at least the initial goal of anyone who's entering the lottery. So as I mentioned, existing license holders can't apply, but anyone who's on the wait list for the initial lottery can apply. And Karen pointed out to me before we started today that those waitlisters will have to withdraw their initial submission for the first lottery. Is that right, Karen?
Yeah, that's correct. Surprisingly, those who are on the wait list of the first lottery are still on there, regardless if seems like a moot point. So when you're thinking about applying for this particular lottery, because it is a separate process, you do have to withdraw your previous wait list and reapply for the second one. It will make more sense when you're actually going through that application process.
Yeah. So if you're on the first page of the wait list, you might want to consider that. You might want to consider staying there. For the other 17,200 or so, you're probably safe to withdraw. I say the first page because the lottery period is not over yet. So it's possible that of the 25 initial licensees, Karen and I were discussing this earlier as well, if one of them falls afoul of either the lottery rules or any of the legislative rules on governing their license or any of their license conditions, if their license is revoked, the AGCO is going to resort to the wait list. So it's not entirely inconceivable that a few more people on the wait list, the top few, might have an opportunity over the next year. So the basic rules, other than that waitlisters can apply, are anyone submitting an expression of interest can, together with their affiliates, submit one expression of interest per region. So it's not a single one, it's one per region together with your affiliates, or your affiliates. But of course, if you're submitting for multiple regions, you're going to have retail space secured in each one. you can only win one license. So as soon as you win one, you're automatically removed as a participant in the lottery for other regions. Unlike in Lottery Round 1, this time lottery participants will need to demonstrate that they'll be able to satisfy certain pre-qualification requirements. Those are that a retail space in the region has been secured, and that there is access to sufficient capital to open a cannabis retail store. And I should be, oh no, I'm still here. Very little detail on some of these slides. I apologize if people were hoping for more. There's a little bit more later, but we put this together fairly quickly. So, of course, we're always going to be able to answer questions afterward if you have any. In any event, the AGCO determined that the amount required to open a cannabis retail store was $250,000. I don't know if they think that's the actual amount. It's many listeners will probably appreciate it's not a particularly high number, especially given initial inventory and other startup costs on top of required capital expenditures to actually build out the store. In any event, at the time of submitting the expression of interest, participants will have to submit a letter signed by them, providing details about the proposed premises and the applicant's legal interest in it, a letter from your bank confirming that you have the financial capacity and creditworthiness to obtain the required $50,000 standby letter of credit. So again, that's not the letter of credit itself. It's a letter signed by the bank saying that they'll be prepared to issue you one. And you'll also need to submit a letter signed by your bank confirming that you have access to $250,000. The forms of letter are on the AGCO's website, so you should be sending those to your bank account manager. And you'll see that the letter specifies that the $250,000 must be available in the form of liquid funds and/or credit facilities. But then if you look at the lottery rules, you'll see that liquid funds is actually meant to capture either cash or short-term investments. So for applicants who are hoping to rely on their ownership of, say, liquid securities, that may be an important point to point out to your account manager if there are issues with having that letter signed. Unfortunately, it's unclear what exactly the AGCO means by short-term investments. It's not defined. Presumably, it would include things like redeemable GICs, but it could be any other number of things, such as publicly traded equity or fixed income securities. Unfortunately, at the end of the day, it's left to the discretion of the bank or a particular bank account manager, which is anyone who's dealt with different banks understands that there's a lot of variability in how bank branches act. And it'll be up to each branch to determine whether its clients' assets constitute sufficient quote-unquote liquid funds or credit facilities, because they're the ones who are going to have to be comfortable signing that letter. In any event, those are the three documents needed at the time that the EOI is submitted, and have a look on the AGCO's website for the forms. Then, once you win the lottery, within 5 days of the announcement of the lottery winners, or notification to the lottery winner, the winner would have to submit proof of their right to occupy the premises, so that's a lease or proof of ownership or some other document evidencing a right to occupy. You'll have to submit the $50,000 letter of credit itself, and you'll have to submit both the retail operator license and retail store authorization applications together with their $10,000 application fees. So, this will inevitably be much more effective in limiting the number of lottery participants, and that's probably appealing to all of you listening on the line. So, on avoiding disqualification, we've already talked about some of the eligibility requirements, so satisfying those are going to be the key, and some of the key issues to bear in mind are you can't change your applicant type or the legal entity name used in the expression of interest. So in other words, the retail operator license and the RSA, the retail store authorization application, they have to specify the same applicant entity, essentially. Also, the applicant can't undergo a change of control at any point following submission of the EOI until, as I mentioned, until July 3, 2020, which is the new end of the lottery process period. That is, unless the regulations are amended yet again before that time. Applicants or their affiliates can only submit one expression of interest per region. The applicant cannot be a licensed producer or an affiliate of a licensed producer, and the applicant cannot already hold a retail store authorization or be an affiliate of the holder of a retail store authorization. So I've been, not so subtly emphasizing the word affiliate in the last 3 points, and I think, and the reason is because ensuring eligibility for some people will depend on an understanding of the meaning of this word, of the defined term affiliate. It's the Cannabis License Act regulation that defines what an affiliate is. And fortunately or unfortunately for most, it's not the usual corporate law meaning of affiliate, which relates only to parent-subsidiary relationships or entities under common control, primarily. This definition for cannabis retail licensing purposes is drastically more broad than that. So this is not an exhaustive list, and in fact, given the drafting of the regulation, an exhaustive list that's easily explainable even to lawyers is a challenge. But here's an example, or examples of what constitute an affiliate under the Cannabis License Act regulation, and mean that if you are partnered, if you have an affiliate relationship, you need to think about yourself and those affiliates as a single entity for purposes of applications. In other words, you can't apply for, you can't submit an expression of interest in the Toronto region if one of your affiliates has already done that. You'll both be disqualified if that's the case. So affiliates are not just corporate parents, subsidiaries, or sister companies. They're other partners in a partnership. They are a trust where the applicant is a trustee or a beneficiary of the trust. Where a licensed producer is involved, the licensed producer itself will be an affiliate of an applicant if the licensed producer directly or indirectly controls a majority of voting shares of the applicant, if the licensed producer directly or indirectly owns shares representing a majority of the fair market value of the corporation, so a majority of the economic interest, or if the licensed producer has direct or indirect ownership or a right to acquire 10% or more of the applicant's securities. It goes on. Two persons are affiliates of each other if they are members of the same joint venture, unincorporated association, unincorporated syndicate, or unincorporated organization. The challenge for lawyers is that none of these phrases have any single clear meaning at law, but the intention is pretty clear. Anyone that an applicant essentially is working with in pursuit of a venture, whether part of the same legal entity or not, whether it's put on paper or not, is an affiliate of the applicant. And if that's discovered by the AGCO, it'll disentitle both of them or all of them to being able to win the lottery. Or if they're already license holders, it'll cause the revocation of their existing license. And as if that all isn't broad enough, the definition adds another catch-all. A person is deemed to be an affiliate of another person if the other person, or group of persons acting in concert, has any direct or indirect influence that, if exercised, would result in control in fact of that person. Again, direct or indirect influence that, if exercised, would result in control in fact of that person. So it's not a legal question. It's really a much more holistic analysis, and Karen's going to talk more about that a bit later. But depending on how that language is interpreted by the AGCO, and It's just as hard for them to interpret it as it is for anybody else. But that type of language could implicate any number of third-party relationships, such as those with lenders, landlords, or licensors or franchisors. And that's because in traditional versions of those relationships, there are often circumstances where the third party can acquire a legal right to take control of the business. So, we know from round one that the AGCO has permitted lender relationships, of course, and also certain brand licensing or service provider relationships that bear some similarity to franchise arrangements, but are not clearly franchise arrangements. So it's certainly not impossible to partner up in the space, but winners of round two really want to be careful to navigate, the adverse consequences of inadvertently agreeing to terms with third parties that the AGCO might interpret as creating this affiliate relationship with an impermissible third party, such as a licensed producer or an entity that already has an interest in another store. And also to avoid the risk that the AGCO will determine that certain terms of the relationship indicate a ceding of legal or factual operational control. That would be in contravention of both statutory obligations that the license holder be the one who's operating the store, and also the lottery rule that prohibits changes of control until July 2020. And we'll talk more about the practicalities of lessons learned from round one in a little bit. We've already talked sort of about the implications for round one lottery winners and waitlisters. Basically, round two is entirely separate from round one. Waitlisters need to submit a new expression of interest and withdraw from their initial expression of interest in order to participate. And as I said, the definition of lottery process has been extended from ending in December 2019 for the first round winners to ending in July 2020. The key for them there is that, or at least one of them, is that the rule prohibiting changes of control lasts for another 7 months. So if some of them were hoping to sell their business in January 2020, they don't get to do that anymore. Quickly on First Nations, we already discussed a little bit, but basically an applicant has to have band council approval, and the AGCO will consider applications on a first-come, first-served basis. Applicants must submit a retail store authorization intent to apply, and that's, like everything else, through the IAGCO portal. I guess generally on First Nations, many First Nations are not happy with how the cannabis licensing regime is shaking out for them. So it'll be interesting to see where licensed cannabis retail stores appear on reserve. But I think that topic deserves its own webinar. So that's really it. The next slide is just to set out, as I'm sure most of you have already mapped out for yourselves, this is the actual lottery process. The EOI window opens on August 7th at midnight, closes at August 9th at 8 p.m. You'll have to submit those 3 documents together with the EOI and the $75, I think it's the $75 fee. The draw happens on the 20th. The announcement of the winners will be on the 20th or the 21st. And winners have to submit those 4 documents that you're looking at on your screen within 5 business days from the notification date, whether that's the 20th or the 21st. So that's all I have on the lottery rules, and at this point I think I should turn it over to Karen.
Yeah, and just to clarify on the notification of the lottery winners, the notification will go to the winners first, and there will be a lag as to when it's public. So those who are interested in, just like the first round, seeing who those people are and then pouncing on them, you won't quite have that opportunity, because by the time that you know who publicly the winners are, they would have submitted their application for their various licenses and authorizations. So after you are a winner of one of these licenses, or the lottery, the eligibility to put your application in, There are a laundry list of other information that the AGCO is going to request from you, and that list is already out there on their website. The due diligence that the AGCO does is going to fall on to sort of two levels. So the AGCO will do their first take to make sure that the rules of the lottery were permitted, and the focus here, and where I think a lot of people try to get creative, is on the application type, trying to change the ownership and control to sort of have that quick sale of the licenses being resold. And so they're very, very keen on making sure that that is not the situation, and it was not the situation for the first 25. And so they're very keen on making sure that there is no change of control, there's no change of ownership, and also that in this particular round, that your lease location is the location of that you put onto your retail store authorization. From some of the questions that we've seen already been asked, I think a lot of people are trying to avoid what happened in Alberta by signing leases and then realizing that they didn't have a license to go on, and then are stuck with that huge liability. The AGCO has, if you do read the rules, they do have a little bit of wiggle room. The wiggle room is not to allow someone to simply say, oh, the landlord didn't agree, we couldn't come to terms on the license. That's not what it's there for. What it's there for is for situations so that somebody, for example, who was originally on the wait list, gets notified that they are now a selected applicant, and that person has, ideally, they don't want to hold that waitlister to that particular location because it's quite costly to go into such agreements. So there is some wiggle room in sort of those extenuous situations, but it's not meant to advert for somebody to simply satisfy the lottery rule by putting in any old address or putting their home address and then saying, okay, well, now that I have the applicant, I've secured a new address. That's not what it's there for. But there is some wiggle room in certain situations that there is a problem with the location that they have secured and can no longer use as their premises. So that's sort of the basics. And then the second level is a third-party independent due diligence review. And where that helps the AGCO is sort of round out this sort of star diagram that I've put out in front of you. The first one is they're looking for, as Jeremy has said, safe, lawful sale of cannabis and consistency with the legislation. And so that first part in terms of personal, they are doing background checks of all the individuals that are associated. So even hiding behind a corporation does not preclude the AGCO from looking at the directors and officers, the owners, shareholders, and seeing where those ties are. Their greatest concern is the connection to the illicit market and organized crime. And so, going through the various webs of your relationships, both personal and business, in this particular business, they will use whatever means necessary to ensure that they've done their due diligence and that we have the right lawful citizens that are operating these stores. Because, at the end of the day, they're still going to have to be able to abide by the laws and regulations, and those are usually the same people who will do so. The others is, understanding your history with cannabis. Obviously, it still is prohibited for anyone who was operating an illegal dispensary subsequent to October 17th. Those people still prohibited from obtaining a license. And then moving on to control, which, as Jeremy has also mentioned, is quite the catch-all. Control is very different from ownership. And this control, what I'd like to kind of point out here is that control can change. If you have partnered with or you are one of the larger companies, control and ownership changes quite fluently with acquisitions. Control changes with even the way that you handle shares to your directors and officers. So it is something to always be cognizant of, and something that if you're planning to partner with one of the larger, more sophisticated retailers or other, you have to really look at what current partnerships and affiliates or potential affiliates that they have, and what would push them into becoming an affiliate. Because at the end of the day, the last thing you want to do is have something that's completely out of your control, but one of your interested parties turns into an affiliate. And as Jeremy has mentioned, both of you are now affiliated, and that's not allowed under the rules. And so that would potentially jeopardize one or both of your licenses. The other main things that they're looking at past that is, like I said, all the interested parties, not because they want to prohibit people from making good business decisions and succeeding, but the rules, especially surrounding licensed producers, is large, and as well as I mentioned, the connections to organized crime. So those are some of the main things that they are looking for. The AGCO and the independent reviewers will use all methods and means available to them to seek out the necessary information to get comfortable about the parties and all your interested parties. As Jeremy has mentioned, those who are financing, those who are supporting, those who are consulting you, and also your landlord. Right. So I think this is where I think a lot of people want to learn a little bit more is what did we learn from the first round? The biggest one is this is not a cheap investment. I know that the AGCO is has a $250,000 requirement, and I'm sure they have definitely put some thought into what that number should be. But at the same time, don't use that as an indication as to how much this is going to cost. The order alone, to be able to make your first order of 25 kilograms, will run you close to $1 million. So there's, that's just the ordering of the product, let alone anybody who's tried to put up a brick and mortar understands how expensive it is to do so. And the cannabis industry is like saying wedding. As soon as you say wedding, everything is triple the price. So that's still the same. That is very much the way the cannabis industry works. So this is not very cheap, and you have to take those the capital investment and into consideration when making your agreements, but also take the operating costs. One of the biggest pain points from an operations perspective was the product, and that comes for a couple of reasons. First is ordering. I think a lot, the amounts that you order, once again, you order probably either, what a lot of them did was order to the capacity that they could, either from an inventory perspective or from a financial perspective. What they didn't kind of take into account was, one is that you have to pay for your order in advance. The government is not going to give you credit. You're paying in advance, and you're taking a gamble on the products that you have ordered. The option to order was only once a week. So, what happens in the middle of the week if you run out of product? You don't have the ability to make midweek orders to sort of bring up that sales amount. And so they found it very restricting. And at the same time, not everything is available. As most of the industry is aware, as there still is there is still a supply shortage. It's changing as the months go on, and OCS has entered into more agreements with other licensed producers, and has been working through their wholesale and distribution channels, and they're slowly learning and they're coming on board. So they do, everything is getting better, but you still have to take that into consideration, that your product's not going to be on the store as necessarily as you might expect it to be. The other one is tracking. Tracking is a big responsibility, both federally and provincially. A lot of the retailers were having issues, for example, with barcodes. Just the way that the barcodes are situated made it difficult for scanners to read them. Just the usual errors in, clicking the right SKU from the person at the cash. And that has sort of led to a bit painful and untimely reconciliations depending on the inventory or the POS system that they're purchasing. So that has been a little bit of a difficulty managing. The other one is also quality of product, and I think this is always a topic for this entire industry. A lot of the consumers are starting to look at the packaging dates because there currently is no expiration date on any of our products. They're starting to use packaging dates as a way of understanding when or how fresh the product is. And so what that has left is many retailers with the inability to sell certain products that are either even from 6 months to even as short as 3 months old, because their customers just don't trust anything past a certain packaging date to be fresh. And like I said, as I mentioned, you've paid for this in advance. It's not a health issue, so it's not on recall. So our retailers are trying to figure out, what do I do with this product? According to the standards, you're supposed to destroy them after every monthly, anything that's unsellable. So you can just imagine just the amount of wastage. All of a sudden it's turned into a consumable goods, similar to, or depreciable goods, similar to having lettuce or tomato into your stock. So those are...
Sorry, Karen, is that any unsold product that's been on the shelf for a month is supposed to be
I
destroyed?
think it's unsellable.
Unsellable, right. On a monthly basis, you'd
Right.
have to destroy any unsellable product.
Unsellable, and obviously unsellable is, would be determined based on, one is the retailer itself, but items that have been recalled, if, for example, that it was required to be destroyed by the
Right.
licensed producer. So that's just giving some examples. Back to the operational costs, making sure that you have enough float from month to month to endure some of these challenges, because like I said, there's a lot of opportunity, but being able to be resilient and have the cash flow to manage some of these ebbs and flows will really help go a long way. The last one on this page is just picking your partners carefully. There are definitely a lot of people who can help you with the fundamental knowledge of cannabis, help you design, give you that brand, and offer you other consultation. Really consider how you want them to support you and what that means for you in terms of your relationship, your affiliated status, and how that will change. A lot of the people that are probably interested in partnering already have some sort of hand in the existing companies. I think it would be prudent for you to understand what those relationships are and how they will change, so that you're creating a relationship that won't violate the rules, the rules, and at the same time, if that situation happens, you have already a game plan as to how to deal with it, so that you don't necessarily lose your license.
Mm-hmm. Okay. So we're pretty short on time, but maybe we can run through these really quickly. Karen, I think you wanted to talk about the first handful of bullet points there.
Right. So just to be quick, preparing to commence, once again, this time around, there's much more leniency as to having your first sale. October 1st really is all that is being required is to have possession of your facility. So it doesn't have to be ready to sell. Just take possession of that and be able to show that. So there's a lot more leniency. The other one we talked about is the financing, making sure that you have the financing. What I wanted to point out here is, so the banks that you're dealing with, chances are this is your personal bank. If you're an individual, if you are a company, this is the company's bank, and they may sign this letter, this commitment letter for your $250,000. But if you're planning on using that bank for additional funds, for some other financing, right now the banks are still very conservative on this approach. And if you're, it would be a good idea to line up your financing, be it talk to the bank ahead of time, and see if that's a possibility.
There are, so a couple of the questions, a few of the questions actually that we saw on the list are about what banks are going to be willing to issue letters of credit, and potentially are going to be more willing to sign letters. So my experience is that some of the big banks are less willing to entertain retail cannabis clients, but Alterna Bank has, I don't receive any benefit from pointing that out, but it is where we refer clients who are having issues with the big banks. So Alterna, I think, supplied letters of credit for almost all of the 25 first licensees.
That's right.
Yeah.
That's right. They were the ones that supplied letter of credit. However, at that time, and they might have changed their tune, at that time, that was they were hesitant to supply anything else, but some retailers have had the ability to go to their own banks because they have other they have properties or other financial instruments with them. So it really will be on an individual basis, but you will find, I think there still is difficulty going to a bank to find additional financing.
There's another question about banking. Those letters that need to be submitted with the expression of interest, they need to be in the name of the applicant itself. It's not going to be sufficient to the AGCO if that's in the name of a related party, a shareholder, a lender. It needs to be the applicant who's named in those letters.
That's correct. The other one, I'll skip over affiliates because we really killed that to death. Planning for future products. I thought this was, I can't remember if I put this or you put that on,
yeah,
but
I added that one.
I thought this was a great thing to consider because, as obviously legalization 2.0 is just around the corner. Understanding what your retail needs are during that time. Space that you will need. Are you considering refrigeration? Are you considering warming capabilities? What kind of display space? And then that sort of leads into how do you buy. So just being sophisticated on, having the right consumer data and will really go a long way to help keeping your brick and mortar stores open.
Yeah, the other thing to keep in mind, at least on the back burner of your mind, is that Health Canada recently announced a consultation for cannabis health products, a potential new class of cannabis product, sort of a cannabis drug that's allowed to make therapeutic claims for the treatment of minor ailments. So that's some ways down the road, but they're proposed to be sold through recreational retail channels, and also by licensed producers who hold a license for medical sale. So that's another interesting one. I don't know if we have time for leasing considerations and other cannabis and non-cannabis business regulatory requirements. There's sort of the usual non-cannabis related requirements. We haven't talked about advertising and promotion, but that's something that everyone in the cannabis industry needs to be aware of. Social media campaigns and certain other things are just essentially non-starters for the promotion of cannabis businesses. So we can, I'm sure at some point prospective retailers will get up to speed on all of those. And there's some key leasing considerations as well that come up in the cannabis context. But we only have a couple of minutes. Maybe we can answer a couple of questions. Karen, there's one that I think we can both sort of answer. I think half a dozen people have asked what happens if multiple expressions of interest identify the same retail store premises. I know that that's not a problem at the expression of interest stage. The AGCO is not going to disqualify anybody just because the same retail premises is identified. But the question, but the subsidiary question there is what happens if two people win for the same space? I don't know that the AGCO's thought about that question because it seems relatively unlikely, but do you have any insight there?
Yeah, actually they are aware that this is a situation that is happening. It's been brought to their attention. And this would be, like I said, one of those situations that I think, once again, depending, for example, if two people win in the same region and these, for example, these people are not affiliated, they pass all the other tests, this might be one of those, they allude to that this would be one of the situations where, if the second person needed to find a different location that would be acceptable.
They'd let that happen.
Yeah, because, there would obviously have to be proof that at the time that they made the application, at the time that they put their expression of interest, that this was a legitimate agreement, or
in other words, that they weren't
MOU.
affiliates. And I guess that would be the other question, right? Is they'd want to decide whether the three people who had submitted for the same location had a relationship with each other, which would be problematic.
Right. So, so you'd have to go through that first test because only one of the affiliated parties would win, and that would be in the order of the lottery. And then second would be, was that a legitimate MOU that was done with the landlord, which would have solidified if and when the application was processed.
Yeah. Interesting. Well, there are other questions. We're at 4:01 though, so I think we need to stop. Thank you everybody for listening in. Karen, thank you very much for participating. And we'll both be available to answer questions that people might have